Welcome to the 36th lecture of this lecture series on international arbitration practice. This lecture is a part of chapter 3 on responding to invocation of arbitration and defenses in international arbitration. In the last lecture, we had introduced the topic and discussed perimeter defenses in international investment arbitration. In this lecture, we deal with defense arguments relating to entitlement to rely on the investment treaty. Like in the last lecture, we continue to rely on the work of Jorge E. Viñuales. So, what is this defense regarding the entitlement to rely on the investment treaty? It refers to inappropriate conduct of the claimant or a person relying on the treaty which has the element of negligence or disingenuous behavior. It is not necessary for the defendant to establish bad faith, but negligence or disingenuous behavior will do. Example of such defenses broadly include international public policy, estoppel, acquiescence, extinctive prescription, abuse of right, corruption, and willful blindness. Of these defenses, some of them do not require any proof of intent or willful behavior. For example, estoppel, acquiescence, and extinctive prescription. But some of them require existence of intent or willful behavior. Examples of these are corruption, willful blindness, and abuse of right. Some of the defenses may or may not require intent or willful behavior. They fall between these two extremes. Example is international public policy. In this lecture and in the next few, we will see each of these defenses. First, international public policy. International public policy refers to principles of fundamental importance to a wide number of legal orders. Hence, it is presumed to be fundamental to every legal order and which override any inconsistent instrument, agreement, or claim. As is usual, the burden of proving that an act amounted to violation of international public policy is on the party alleging it. This principle has been successfully employed to defend against claims in several cases. We provide some illustrations below. In World Duty Free Company Limited versus the Republic of Kenya, it's an exit case number R007, award dated 4 October 2006. After the exchange of memorials by the parties, the tribunal ordered a preliminary hearing on the merits of the claimant's claim. One of the preliminary issues framed was whether the claimant is legally entitled to maintain any of its claims in these proceedings as a matter of public policy or ordre public international, including any rule based on the maxims ex turpi causa non oritur actio or nemo auditur propriam turpidinem allegens. The issue arose out of Kenya's defense that the contract was obtained as a result of bribe paid to the then President of Kenya, and that as a matter of Kenyan, English and international ordre public, the resulting contract does not have the force of law. The arbitral tribunal analyzed the law on the issue and held, in light of domestic laws and international conventions relating to corruption, and in light of the decisions taken in this matter by courts and arbitral tribunals, this tribunal is convinced that bribery is contrary to the international public policy of most, if not all, states, or to use another formula, to transnational public policy. Thus, claims based on contracts of corruption or on contracts obtained by corruption cannot be upheld by this tribunal. The tribunal also found that under the domestic law, the claimant was in any case not entitled to any relief. In conclusion, as regards public policy, both under English law and Kenyan law, being materially identical, and on the specific facts of this case, the tribunal concludes that the claimant is not legally entitled to maintain any of its pleaded claims in these proceedings on the ground of ex turpi causa non oitur actio. These claims all sound or depend upon the agreement of 27 April 1989 as amended, and no other claim is pleaded, including any non-contractual, proprietary or restitutionary claim. Next comes the question as to whether this violation of international public policy is curable. To illustrate, the question arises whether a claimant can seek restitution of money lost through bribes paid to procure a contract. Again, the case of World Duty Free Company dealt with this issue and held that there may be legal consequences following the avoidance of the agreement, although restitutio in integrum cannot include the return of the bribe to the claimant. It is relevant to note that the legal consequences of bribery was not pleaded by the claimant in the arbitration. However, several other arbitral awards have dealt with this issue and have held against curing it either on the ground that the transaction did not legally exist, for example Cortec Mining Kenya Limited and Sterling Capital Limited versus Republic of Kenya, it's a 2018 arbitral award, or on the basis of the principle that rule of law required that a court or tribunal should not assist a party which engaged in a corrupt act. On the latter ground, the tribunal in Metaltech versus Republic of Uzbekistan held in its 2013 award. As a result of the foregoing analysis, the tribunal lacks jurisdiction over Metaltech's treaty claims as well as over Metaltech's claims based on Uzbek law. While reaching the conclusion that the claims are barred as a result of corruption, the tribunal is sensitive to the ongoing debate that findings on corruption often come down heavily on claimants while possibly exonerating defendants that may have themselves been involved in the corrupt act. It is true that the outcome in cases of corruption often appears unsatisfactory because, at first sight at least, it seems to give an unfair advantage to the defendant party. The idea, however, is not to punish one party at the cost of the other, but rather to ensure the promotion of the rule of law, which entails that a court or tribunal cannot grant assistance to a party that has engaged in a corrupt act. So that's all in this lecture. See you in the next one on the same subject. Bye bye and stay safe.